What does it mean when a judge says, strike the witness's answer? You want to know what it means? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. So now you're at trial, maybe a medical malpractice trial, maybe an accident trial, maybe even a wrongful death trial. And during the course of trial, your attorney asks a question of a witness. The defense attorney jumps up, yells, "Objection, Judge!" The judge says, "Objection sustained." But before the judge had an opportunity to go ahead and rule on the attorney's objection, the witness has already answered the attorney's question. And now, not only does the judge say objection sustained, but he tells the court reporter, you are to strike that answer. What does that mean? It means the jury is not to pay attention to the question, and they are not to pay attention to the answer. That is not to be considered evidence. Why? Because the judge has ruled that the question was improper and never should have been answered. So you might be thinking, wait a second, let me see if I understand this. The attorney has asked the question already, the jury has heard it, the witness has already answered the question, to which he should never have done, but he did it before the judge had an opportunity to make a ruling. It was just a reflex. The attorney asked a question in normal conversation, and the witness automatically responded. So now, what does it mean to the jury? They've heard the question, they've heard the answer. The judge says, hey, disregard that question, disregard that answer. You are to strike that testimony. Strike it? How do you strike it? You've heard it. The reality is that nobody can strike it from their minds. Instead, the judge gives them an instruction. Say, listen, that question was improper. The answer should not have been given. It was improper. So you are to disregard that and not consider that ultimately when you go and deliberate and decide who's more likely right than wrong at the end of the case. In addition, that objection is now preserved for an appeal. Now, what does that mean? It means that the defense attorney who jumped up to yell objection because he didn't like the question, if he loses the case, and now the jury has already heard the question, heard the answer from the witness, it's possible that if he loses the case and now he appeals that case, he can argue, or maybe one of the things he can argue to the higher court is, listen, that ruling changed the entire outcome of this case. The fact that the jury heard this information, they never should have heard it, the witness never should have answered it, and because they did, they now ultimately reached a different conclusion than they should have. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these trials involving accident cases and medical malpractice cases and even wrongful death cases. You know, I recognize you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that you need to get answered first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.